If your asylum case is pending in immigration court, you need to see this video because I'm going to tell you about an important decision that you may need to make. In fact, it's so important that it could have lifelong consequences. And I'm going to share what is probably a pretty controversial opinion on the topic of when you should seek to have your asylum case dismissed and when you should try to fight it out to the very end, even at the risk of receiving a deportation order. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, I help immigrants all over the country to secure their future in America through asylum. In immigration court today, my asylum client was faced with a really difficult choice: whether to go forward with presenting his asylum case, after which the judge would make a final decision, or to instead have the case dismissed. And he decided to fight the case despite pressure from the judge and the government prosecutor to have the case dismissed. And it ended up being the right decision because we won the case. He was granted asylum. Now, let me back up and explain the choice here, which may well be one that you will have to make in your asylum case. You see, the Biden administration has decided that certain people in deportation proceedings simply aren't a priority, and that the Department of Homeland Security, known as DHS, should not spend its finite resources on trying to deport them. If the person doesn't have a criminal record, and if they meet a few other requirements, the prosecutor, who works for an agency called ICE, may try to get the case dismissed. Now, when an immigration court case gets dismissed, it goes away. The person is no longer in deportation proceedings, which is usually considered a good thing. But on the other hand, when a person's case is dismissed, their asylum claim disappears. This means that they cannot renew a work permit based on a pending asylum case because they don't have a pending asylum case anymore. And they also can't get asylum unless they apply again, which they can do by submitting an application to the immigration agency called USCIS. And this may be a good option for people who never had an asylum interview with USCIS and instead have only had immigration court proceedings. If these people apply with USCIS after having their case dismissed from the immigration court, then they'll have an asylum interview at an asylum office and can try to win their case there. But it's different for people who did have an interview at an asylum office and who then had their case sent to immigration court. If their case is dismissed from court and they apply now with USCIS, that agency is going to pass the case straight back to immigration court. And this means that dismissal is less desirable for people who previously had an interview at USCIS and now find themselves in immigration court. And that was the position my client was in. He came to the United States on a visa from Venezuela, and he applied for asylum with USCIS, got a negative decision there, and was referred to immigration court. Now, we had discussed before his final hearing in court whether he wanted to have his case dismissed. He knew what the benefit of this would be, that he wouldn't be at risk of receiving a deportation order, which is what would happen if he continued with his case and the judge had decided that he was not eligible for asylum. And that's a serious thing, risking a deportation order. Even though my client had temporary protected status, known as TPS, which would protect him from actually being deported for the foreseeable future, a deportation order could someday mean that he would have to actually leave the United States. But you see, my client wasn't satisfied with just having TPS because that's not permanent and it does not lead to permanent immigration status. Asylum, on the other hand, leads to a green card, which in turn can lead to US citizenship. So the benefits of asylum are, in a word, huge. And my client believed in his asylum case, even though USCIS had previously told him that he did not deserve asylum. So he was willing to risk getting a deportation ruling in order to have his asylum claim heard in full, in order to try to win asylum. So we discussed all the pros and cons of having a case dismissed before the hearing, and my client was resolute in his stance that he wanted to reject the prosecutor's offer to jointly ask the judge to dismiss the case. So that's what we did at the hearing. We told the judge that we were respectfully declining the prosecutor's offer to join in a motion to dismiss the case. Now, the judge was surprised, and in fact, he pressured us to go along and just have the case dismissed. This would mean less work for both the prosecutor and the judge, so they have an incentive to push for dismissal. But we stood strong. We had to keep insisting before we were finally allowed to move forward and do the hearing. And we won. My client got asylum. But what gave him this confidence to take this risk? Why not take the safe route and just have the case dismissed? Well, we put together a solid case for him, and we worked extremely hard to get him prepared to explain his case to the judge. You see, we laid the groundwork with a comprehensive filing that showed the judge everything they needed to see to connect the dots, to see that my client met all the requirements for asylum. It consisted of a detailed declaration from our client, documentary evidence backing up our claims, and a legal brief that I wrote in which I applied the facts to the law to show that a grant of asylum was required. And then we did multiple practice sessions, so my client knew what kind of questions to expect and knew how to explain his case in a compelling way. He was prepared to answer difficult and likely hostile questions from the prosecutor and the judge. We put in the work, so our client was confident when it came time to make that fateful decision of whether to go forward with the case or instead back down. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. Now, understand that deciding to fight the case isn't going to be the best decision for everyone. You do need to have a legitimate case. You have to have a chance to win in terms of what has happened to you and why you fear being harmed in your country. You should definitely talk to an asylum lawyer to assess your case's strengths and weaknesses before deciding whether to seek to have your case dismissed. But I do want to stress that I think many immigration lawyers are too conservative on this issue and automatically say, oh, you need to get out of deportation proceedings, so let's go ahead and try to get this thing dismissed, without carefully considering the prospect of fighting the case. Personally, I say if the facts of your case give you a fighting chance and you're willing to put in the work with an experienced asylum lawyer to develop the case and to prepare intensively for your hearings, then you should really consider fighting the case rather than agreeing to have it dismissed. Ultimately, this is a tough and really important decision that requires your careful consideration. If you'd like our help in working through this, then call my office today. That number is 713-352-1593. And remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.